and Miller.
My Lords, I represent Times Newspapers Limited with my learned friend, Miss Kate Wilson. Those opposing me for Mr. Flood, the respondent, are Mr. James Price, who sits behind me, and his junior, Mr. William Bennett. Will your Lordships forgive me if I don't run through the whole of the cast list?
Yes.
It's written
You have it written down, don't worry. It's a very sensible use of time.
For the same, excuse me, for the same reason, I don't need to give any sort of a summary about the facts of the case because it's here on a piece of paper written not by me. Any salient facts that I need to emphasize, I will do in the course of my submissions. Lords, this is essentially a case about the importance of a free press and in particular about the importance of what I call public interest journalism. Penalties are threatened or have been imposed against Times newspapers for having published what was, by the decision of this court in 2012, a very high-ranking piece of public interest journalism. And that's really what underlies both halves of my appeal. The first half is peculiar to Times newspapers. It is that in order to pay the costs of the part of the case which they won, that is to say, the Reynolds defence which they established before Mr. Justice Tugendhat and in this court, they should have to pay the costs of that part of the case. The second issue that I address is the same one as all my other learned friends here, which is the question whether it is right in a publication case to impose the additional liabilities by way of success fees and ATE insurance premiums. So we join with them on that issue. May I, at the risk of being told to sit down, as it were, or shut up, put forward what I regard, what we regard, and perhaps the court will agree, it's not, I hope, controversial. What are some axiomatic principles in relation to freedom of the press, and in particular what I call the serious press, or the media? First, freedom of expression is vital to the health of a democracy. There's plenty of authority of every single one of these axioms, if I may call them that. Some of that I will show to your lordships very briefly after I've finished doing this. The second is that the role of the media is vital in serving that interest. Media means exactly what it says. Even in the age of social media, newspapers and broadcasters are the means, the media, by which the citizens of a democracy get much of the information that they need to make effective decisions about the world they live in. Perhaps in the post-truth age, I can say that now because it's now in the Oxford Dictionary, the role of those committed to the traditional values of serious journalism is even more important. Fake news has to be combated by real news. The greater the public interest, this is the third, the greater the public interest in a particular subject, the greater the importance that the media should convey that information to the public. It follows, that, using the words of the European Court of Human Rights in Strasbourg, that the media have two roles to play, which they must be allowed, so far as possible, to continue to play without interference. First, they play the role of bloodhound, that is to say, discovering information that the public needs to have, and the role of watchdog, that is to say, ensuring that such information is neither suppressed nor ignored. Information is brought to light, as in this particular case, which has not apparently been acted on by the appropriate authority. The press is the watchdog that ensures that that sort of inertia is not allowed to persist. Finally, in consequence of all of that, it is necessary to ensure that the media's discharge of those roles, whether they be print or broadcast media, is not unduly restricted or inhibited by, for example, the imposition of exorbitant financial penalties. I use the word exorbitant in its strict sense, that is to say, outside the recognized ambit of permissibility. Exorbitant financial penalties that operate as both a particular, in the case in hand, or in relation to the defendant in question, or a general deterrent to the discharge of both those roles. The question of general deterrence is very important, obviously. Heavy penalties routinely imposed on press or broadcaster will result in an inhibition, a discouragement, an unwillingness to indulge in the kind of journalism which has invoked or provoked the penalty. It costs money to do an investigative television program. It costs money to send reporters out into the field to get information for publication in the newspaper. The greater the disproportionality of the penalties imposed on such activities, the less frequently are they going to be done. So the more the public interest suffers. That essentially, my lords, is what this case is about. I make that good to some extent, if I may. I may be forgiven, I hope, for this. If I return, excuse me, to the case which is at the foundation of the whole of this appeal, which is flood against Times newspapers in this court in March 2012. It's to be found in the core bundle, the first of those floppy blue volumes. In the appendix, the appendix is at tab 7, and the judgment of this court is at tab 16, and the page number, which I gather I have to have for electronic purposes, is page 439, I'm sorry, which is where it starts.
Thank you. Yep.
The first judgment is given by Lord Phillips, who was then the president of this court. And he does two things. He expresses his view, indeed his judgment, about the quality of the material that was published, its status as public interest material, and also about the quality of the work which was done by the journalists in obtaining that information for publication in the Times. These references are quite short. The first reference in the judgment of Lord Phillips is on page 464 at paragraph 68. There is a excuse me. There is a subsidiary issue to which some of this material, I'm doing now so I don't have to come back to it, some of this is material to the question whether or not the Times should have settled this case before the trial of the Reynolds issue. At 68, he says this: I have set out in full in paragraph 104 of the judgment of Lord Justice Moore-Bick, because he identifies matters that will often weigh conclusively against publication of details that appear to support an accusation that has been made against an individual of criminal conduct that's being investigated by the police. May I drop down some lines to a sentence which begins, I have reached the conclusion, and this is Lord Phillips speaking, I have reached the conclusion that subject to the issue of verification, that is to say, an examination, the issue of verification, an examination of the steps taken by the journalists to see, so far as they could, how well supported the allegations which they were reporting were. That can then be measured against what they actually said in the publication. The golden rule is don't go further than your sources will allow. Don't assert that it's true if all you have is a suspicion. That's the character of the exercise. Back to the text. Subject to the issue of verification, it was in the public interest that both the accusation and most of the facts that supported it should be published. The story, if true, was of high public interest. It's maybe a little tiresome, but I will, if I may, in each case that that principle is advanced or that proposition is advanced in this judgment, I will refer your lordships to it. At the bottom of paragraph 69 on the next page, 465, the last sentence. Michael Gillard, he was one of the journalists, Michael Gillard's concern, coupled with the high public interest of the story, justified its publication. The concern was that the police were not investigating the allegation with sufficient vigour. There was, in the words of Lady Hale and Jamil at paragraph 147, quotes, real public interest in having this information in the public domain. As I hope I don't exaggerate by saying that this decision of your lordship's court has had a significant influence in our domestic law. It provided, amongst other things, the foundation for the new Section 4 of the 2013 Defamation Act. And then 119, this is Lord Brown, at page 480, paragraph 119. He says, of course, not every anonymous denunciation to the police will attract Reynolds' privilege. Far from it. That, as Mr. Price, QC for Sergeant Flood, was at pains to point out, would indeed be a charter for malice. But whereas here the denunciation is of a public officer, relates to a matter of obvious public importance and interest, and may justifiably appear to the journalist to be supported by a strong circumstantial case, it seems to me properly open to the trial judge to find the defence made out. Three things about that short paragraph. One, the high public interest. Secondly, the reference to the conduct of a public officer. This is something which emerges with some emphasis in the judgment of my Lord Lord Mance in this case, the case here before your lordships. The higher up you go, the hierarchy of officials whose conduct is criticised, the greater the public interest. It's a banal and obvious observation, but it is so as a matter of law. Second thing is the strong circumstantial case. This is important when one comes to consider what it was that the Times were supposed to resile from at the behest of Mr. Flood later on. So those are the three elements of that paragraph. Then I will pass on, please, to Lord, let me make sure I get my references right. Lord Mance at paragraph 179 on page 504. 179, my Lord says this: it follows from the analysis in paragraphs 158 to 178 above that in my view the Court of Appeal erred in its approach and in the reasons it gave for reaching conclusions differing from the judge. Balancing the competing interests in this case, the judge was in my view justified in the present case in regarding the article concerning Detective Sergeant Flood as covered by the public interest defence recognised in Reynolds and Jamil. The starting point is that the investigation into possible police corruption in the area of extradition of a Russian oligarch to Russia informed the public on a matter of great public interest and sensitivity. Moving then on across the page to 181 on page 505, on this basis, there was, in my judgment, no good reason for the Court of Appeal to depart from the judge's overall assessment that publication of the article was in the public interest, despite its immediate adverse effect on Detective Sergeant Flood's reputation. I pause there to observe again, which is blindingly obvious, I know. These cases are now a conflict or a contest, let me say, between, on the one hand, Article 8 and sometimes Article 6, that is the claimant's rights, access to court so as to address or assert his right to reputation under Article 8, and the publisher's right to freedom of expression under Article 10, which also encompasses the public's right to have the information. That's an important additional consideration, as one has seen from what has passed already. The public are entitled to have the information, and the press has a duty to supply it. This is English law as well as I shall show your lordships in a moment when I turn to the case of Reynolds. The press has a duty as well as an interest and a right in passing information of high public interest to the public, who have a right to have it. The next one is at page 506 in the judgment of Lord Clark. Again, a short paragraph. 185. I further agree with Lord Brown that in deciding that question, a host of different considerations are in play. Lord Brown has identified some of them in paragraph 113 above. Finally, I agree with his conclusion in paragraph 119 that whereas here the denunciation of a public officer, again the public officer, relates to a matter of obvious public importance and interest and may justifiably appear to the journalist to be supported by a strong circumstantial case, it is properly open to the trial judge to find the defence made out. And at 190, Lord Dyson, on the opposite page, 507, Lord Phillips and Lord Mance have explained in detail why they consider that there was a public interest in the publication. Most, if not all, of the facts that supported the story in the name of Detective Sergeant Flood. And secondly, why they would hold that the journalists had taken reasonable steps to verify that there was a serious possibility that Detective Sergeant Flood had been guilty of corruption. And then finally, I think it's finally at probably best to go to 201, right at the end of the judgment, page 511, where in the final sentence, Lord Dyson says this: a story that a police officer is being investigated for corruption is prima facie in the public interest, even if the story is published in furtherance of a personal vendetta by the journalist or the publisher against the officer. Not here, of course. That is the strength of the public interest. It may even outweigh the fact that the journalist has a private motive to do down the victim of his publication. 98, 99, yes, I've forgotten that. Thanks very much. I'll do that in a minute. 202, third sentence in Lord Dyson. It was in the public interest for the allegations against Mr. Flood to be investigated promptly. And that was relevant to whether in the public interest, whether it was in the public interest to publish a story about the investigation. That is the watchdog limb of this investigation. Ms. Wilson says I missed two of the important allegations, citations from Lord Phillips's judgment. I need to go back, I beg your pardons for that. 98 and 99 on page 474 in the conclusion. The third sentence, please. The case against the respondent was circumstantial, but I consider that the journalist, together with Mr. Gillard Sr., that was Michael Gillard's father, were justified in concluding that it was a strong circumstantial case. This is important. In 99, Lord Phillips, if one reads the whole of his judgment, had evidently done a very serious and meticulous review of the findings of fact by the judge. And this is what he says in 99, 1, 2, 3, fourth sentence, beginning my initial reaction. My initial reaction on reading the facts of this case was that the journalists had been reasonably satisfied on the basis both of the supporting facts and the action of the police that there was a serious possibility that Sergeant Flood had been guilty of corruption. After a detailed analysis of the case, I remain of that view. One asks oneself, at least we ask the question, which we would propose was probably a rhetorical question, but my own friend may disagree. That being so, how can it possibly be right to inhibit or as it were, penalise journalism of this quality without a very good reason? This is highest possible public interest journalism. Lords, with that in mind, because that is the judgment which underlies the whole of this appeal, so far as we're concerned, may I, at the risk of being told, no, just give me the reference, don't read it out, give some short citations from authority, both in this country and in Europe. I will start, if I may, with a case called the Queen against the Secretary of State for the Home Department, ex parte Sims. That is in volume 9 of the authorities at tab 9. At page 3696. Your Lordships will notice the date of this judgment. It precedes the coming into force of the Human Rights Act. It's a 1999 decision.
It's a case that has not been infrequently referred to in this court.
Well, in that case, I'll maybe just give the reference, but it's in the words of Lord Steyn, it is very elegantly put, and there's only a short paragraph. What I was going to say was, it predates, therefore, the what I might call the formal judicial consideration of the effect of Article 10, because that wasn't part of our law in those days. It also predates the later perception, which I think came from Europe, that Article 10 was in fact balanced by Article 8. In the beginning, Article 10 was balanced merely by 10.1 was balanced merely by Article 10.2, the rights of others. Now we have Article 8 as an equal-footed contender with Article 10 in these cases. the right to reputation and private life. The passage which may be forgiven, perhaps if your lordships just read it yourselves, but it's typically, if I may say so, typically worded by somebody who was, after all, a master of this what do I call, democratic essentials.
Yep.
Question. It's at page 3707.
Thank you.
It's no longer numbered paragraphs. It starts at letter F.
Thank you.
Freedom of expression is, of course, intrinsically important. It's valued for its own sake, but it is well recognized, also instrumentally important. It serves a number of broad objectives. First, it promotes the self-fulfillment of individuals and society. Secondly, in the famous words of Holmes J., echoing John Stuart Mill, the best truth is the power of the thought to get itself accepted in the competition of the market. One may wonder about that these days. Thirdly, freedom of speech is the lifeblood of democracy. The free flow of information and ideas informs political debate. It's a safety valve. People are more ready to accept decisions that go against them if they can, in principle, seek to influence them. It acts as a brake on the abuse of power by public officials. It facilitates the exposure of errors in governance and administration of justice in this country. It is this last interest which is engaged in the present case. For a short paragraph, that perhaps might be thought to say everything.
Thank you.
Then, my lords, next, in the same year, just after the Sims case, the famous case of Reynolds and the Times newspapers, that's in volume 10, at tab 11, at page 3730.
It's tab 1. Tab 1, I think. Volume 10, tab 1. Anyway, 3730, thank you.
3730, yes. This is a case which, although the appellant newspaper, which is the same one as my client in this case,
Yep.
Lost the appeal, the House of Lords took the opportunity offered by the impending adoption of the Convention by Article 10 to create the defence, and it was a creation. It was born of the common law defence of qualified privilege, duty and interest, but it was converted essentially into a defence of public interest for any speaker, but most particularly, obviously, for the media. At page 3803, Lord Nichols, who I would say gave the leading speech, and I won't refer to any of the other speeches, he says at letter D on 3803, my starting point is freedom of expression. The high importance of freedom to impart and receive information and ideas has been stated so often and so eloquently that this point calls for no elaboration in this. At a pragmatic level, freedom to disseminate and receive information on political matters is essential to the proper functioning of the system of democracy, parliamentary democracy cherished in this country. Then dropping down, if your lordships will, to letter G. Likewise, there is no need to elaborate on the importance of the role discharged by the media in the expression and communication of information and comment on political matters. It's through the mass media that most people today obtain their information on political matters. Without freedom of expression by the media, freedom of expression would be a hollow concept. The interest of a democratic society in ensuring a free press weighs heavily in the balance, and deciding whether any curtailment of this freedom bears a reasonable relation to the purpose of the curtailment. That's very important. That's the balance. In this regard, it should be kept in mind that one of the contemporary functions of the media is investigative journalism. This activity, as much as the traditional activities of reporting and commenting, is part of the vital role of the press and the media generally. Then, my lords, over, please, to the bottom of page 3807, at letter G, conclusion. My conclusion is that the established common law approach to misstatements of fact remains essentially sound. The common law should not develop political information as a new subject matter category of qualified privilege, where the publication of all such information would attract qualified privilege, whatever the circumstances. That would not provide adequate protection for reputation, the Article 8 right. Moreover, it may be unsound in principle to distinguish political discussion from discussion of other matters of serious public concern, as, for example, the suspicion that a police officer might be corrupt. The elasticity of the common law principle enables interference with freedom of speech to be confined to what is necessary. This now is a convention concept. Confined to what is necessary in the circumstances of the case. This elasticity enables the court to give appropriate weight in today's conditions to the importance of freedom of expression by the media on all matters of public concern. And then finally, my lords, at letter F on the next page, 3808, third sentence, above all, the court should have particular regard to the importance of freedom of expression. The press discharges vital functions as a bloodhound as well as a watchdog, so there is Europe imported into this jurisdiction. The court should be slow to conclude that a publication was not in the public interest, and therefore the public had no right to know, especially when the information is in the field of political discussion. The last sentence of this paragraph, my lords, has since been doubted and for the most part not applied because of the recognised balance now between Article 8 and Article 10. Lords, may I go briefly, and it is quite briefly, to Europe, so as to emphasise in a way the convergence of English and European thinking on this topic. The first case is, again, a case from the same year, 1999, a bit earlier, May 1999. It's called Bladet, Tromsø and Stensars against Norway. It's volume 11, tab 7, page 4498.
4498.
4498, Lord, yes. And it contains...
Yep. Yeah.
It's the Norwegian seal hunters case.
Yes.
Sorry, I've just momentarily lost my place.
Right.
Yes. At paragraph 64 on page 4542, there is what has become, in Europe at least, and to some extent in this country, I don't know quite what the word is, it's a watchword, or it's an axiomatic statement of how these sorts of cases should be approached. And it is absolutely critical to this appeal. The most careful scrutiny on the part of the court is called for when, as in the present case, the measures taken or sanctions imposed by the national authority are capable of discouraging the participation of the press in debates over matters of legitimate public concern. This, fortunately for us in this jurisdiction, is a matter which falls within the purview of the court, as it does in Europe. The court is there to ensure that lower courts shouldn't do it either, but if lower courts exceed what I might call the margin of appreciation in imposing sanctions on the publication of matters of public concern, that right will be eroded, if not destroyed. Repeated imposition of disproportionate penalties leads to a drying up of information of public concern and hence becomes a diseased part of our democracy. If we don't get the information, we can't run our lives, put it in everyday terms.
Can we just ascertain more precisely what we're talking about in financial terms?
Yes.
We're not talking about the appellate costs.
No.
We're talking simply about the costs at first instance, and we're talking against background where the sole issue until, I think, June 2009, until the reply was put in, was
yes, that's right.
Whether the Reynolds privilege applied or whether there was justification in respect of the publications up to, well, all the publications, without any suggestion that there was anything special in respect to the period after September 2007. Is that right?
Up till then, yes.
And then in June 2009, in the reply, comes the suggestion, which proves correct, that in fact the website publications after September 2007 are in a different category.
They are indeed, and I have to come to that in due course.
But you've been ordered to pay the whole of the costs.
I don't know exactly what the costs, it hasn't yet been divided out. I don't know exactly what the costs attributable to the Reynolds defence up until, we already have the cost of the Court of Appeal, because your Lordships overturned the Court of Appeal's decision, and in that process, the Court of Appeal were against us 3-0. But they lost, as it were, 5-0 in, I beg your poor Lordship's pardon, 5-0 in this court.
Perfectly fair description.
Yes.
Yes, so you got the costs of what everything? Did you Court of Appeal and...
The Supreme Court was no order.
No order because of the terms on which
Yes,
leave was given.
That's right,
Permission.
exactly so. A protective device, if you like, for Mr. Flood.
Yeah, so you simply got the cost, no order in the Supreme Court, you got the costs of the Court of Appeal.
Yeah, but that's right, as though...
On that issue.
On that issue at that stage, yes.
Yes.
Then we went to... Well, your Lordship,
As you had to pay the
Lordship-
costs of the
your Lordship-
website.
Sorry. go on.
So you had to pay the costs of the website issue.
And rightly so, because we made a mistake and didn't put up the change of circumstances notification, what we should have done. And so there was a cause of action. There wouldn't have been, had we done so, the case would have ended there.
Now, I mean, some division will have to be done in respect to the Court of Appeal costs between costs attributable to each issue.
Yes, but that's a P against a giant mountain.
Your complaint is basically that no division has been done.
Lord Newberger, the President, may remember that in the Court of Appeal the matter took about 5 minutes and the judgment knocked us through the floor in about 4 words. So it was a very minor part of the debate in the Court of Appeal.
Yeah. And you say it was a very minor part of the debate. Well, Dean, it wasn't any part of the debate until shortly before the hearing in front of Mr. Justice Tuke.
Well, there was some debate. I suppose it took about 20 minutes, and the written arguments on that issue were very short.
What, in front of Mr. Justice
Yeah, in
Tuke?
front, there was some, but very little.
Yes. Well, his judgment indicates...
Yes, it does. That's right. It's a long judgment, and it's a short section at the end.
But your argument is that there's a deterrent effect here. It's a bit difficult to know. I mean, do we just have to sort of try and get a feel for what percentage of the cost is being imposed on you, which wouldn't be imposed if an issue approach was taken?
Well, I'm not able to give your Lordships a figure because I don't know it, and I don't know that anybody's determined it yet. What actual figure is attributable to the costs which we haven't had on the Court of Appeal and which we weren't able to get or didn't try to get in the Supreme Court? What proportion of the costs are what I call the main part of the Reynolds defence? That is to say, up to the failure to post the qualification. What that figure is, I don't know. What I will say, it's going to be substantial.
Well, up till June 2009, presumably it must have been the whole of the costs were...
Well, yes, except that the trial was still to come, as that was July.
Yes,
And now we've been robbed, if I may say so, of those costs too, the costs of the trial as well.
Yes. But it is fair that...
No, my lord, I'm sorry, I should correct that. There was a low-lying, I'll say what I mean by that in a minute, defensive justification.
Yes.
It wasn't a very substantial thing. It was a justification more or less in line with what this court said in the last time round. A strong circumstantial case. In fact, it was grounds for an investigation, was the nature of the true allegation we said.
You didn't need the justification defence if you had the Reynolds defence.
No.
And the Reynolds defence, therefore, looking at it retrospectively, would have been a complete answer to everything which was in issue until June 2009.
Precisely.
By then, huge costs must have been incurred already.
Well, precisely so. I don't know what they were, but they're very substantial. And not only that, unless the additional liabilities are lifted from our shoulders, it's double the money.
Well, on this aspect of the case, what order do you say? Do you have a specific proposal as to what order we should substitute, or
yes,
are you saying we should send it back to the judge?
No, I wouldn't. That's just more money.
Yeah, quite.
So I wouldn't say that.
Another way of approaching Lord Mance's question might be to say, look at the order you're proposing.
Yeah, sorry, I didn't catch that last bit.
Another way of looking at Lord Mance's question, or an answer to the question, may be to look at the order you're proposing.
Yes, that's actually, I don't even need to go to a file for that, because that's set out on the front page of the summary.
Exactly.
That is exactly the order, not the order for damages, we didn't appeal that, and I would say rightly. We were to pay his costs of the action, including the cost of the damages trial, certainly, and the costs reserved by Mr. Justice Tugendhat, not certainly, because that's all the other costs.
But what do you say the order should have been?
The order should have been that we should pay the costs of the damages trial, and that we should not pay, and Mr. Flood should pay, the costs of the Reynolds issue, the defence of privilege. That would include almost all the costs of the trial before Mr. Justice Tugendhat, not the costs of the defence of justification, because we abandoned that.
So technically, would the order be that he would get his costs, save insofar as the costs were attributable to the Reynolds issue, as to which you should get the costs?
Precisely
That
so.
be the precise
Precisely so.
form of
It's relatively simple for once.
Yeah, well, it's simple to state,
Yes.
but as one knows, those sort of orders are very difficult for cost judges to apply.
Yes.
But
Well,
that doesn't mean they shouldn't be made.
I'm not a cost judge, but
Well, I know, but we have to have it.
as a matter of principle, what your lordship has just said must be right, if we're right.
Yes, but normally what judges try and do in that sort of case, to make life more practical, is to try and arrive at a percentage figure.
Well, then you do have to look at the substance of
Well,
it.
the judge is in a particularly good position to do that because he or she will have had the case and have a better idea than anyone else.
I quite agree with
to
that.
apportion.
I quite agree with that. And your lordships could send that decision back to her if you were in my favour. It can't be left as it is because she's made an order which she ought not to have made.
If you're right on the appeal, clearly it can't be left as it is, and there are two options. One is to make an order ourselves, and the other is to send it back. I entirely see the advantage of us making it in terms of cost and time.
Well, it would save everybody a lot of time and money if your lordships were able to do
But
it.
well, I don't know what your suggestion would be if I was the judge sitting at first instance, having had remitted to me, and I said to you, I'd like to make a percentage order if I could. What would your submission be on that? And if you'd like to think about that and take...
Oh, I'd have to think about it.
Please, okay.
Again, I'll try and do it today.
Yes, if you need overnight, that's fine. The reason I mention it is because if you and Mr. Price each come up with a figure, at least it'll give us some idea of the answer to Lord Mancy's question.
Yes.
But don't be rushed into a figure. But that
No, if we can't reach, and I'm not talking about an agreement, but if we, on our side of the court, can't reach a reasonable stab, and it is only a stab,
that's all I'm asking for.
we'll tell your lordships.
Thank you.
Yeah. I would, from now on, I think, because the message is clear, the message is repeated, perhaps only just give a few more references, but very short.
Would it be enough just for you to tell us the page numbers and we can read them in our time?
Yes, it would. I'll give you the year, which is quite important.
Yes, it is.
There's a case called Turnsberg, Blatt and Haukom against Norway.
Thank you.
It's in volume 12, tab 10, page 5092.
Thank you.
And paragraph 88. The court, that's the European Court of Human Rights,
Yes.
Strasbourg, repeats more or less what was said in...
Not an unknown experience.
yes,
Yep.
exactly, about the most careful scrutiny is required and so on.
Thank
and so
you.
forth.
What I tell you
But
three
there
times
is,
is...
if I may just, most careful scrutiny is required, and this is a case about people buying up holiday homes on the coast of Norway, I think.
Yes.
What they did do was they did report what the penalty had been. Now, it's true to say that it was some time ago, it was in March 2007. The penalty which they thought was excessive. Norwegian kroner, this is paragraph, this is just, I no need to look at it, paragraph 102, it's on page 5126. Norwegian kroner 50,000 in compensation. That, Miss Wilson tells me, because she looked it up on something, the foreign currency exchange on the internet, is about £4,500. And costs of 673,829 Norwegian kroner for costs. That comes out at about £61,000.
Now,
No, in 2000, well, I don't know. The last bit she didn't have time to do, which is when you have to recalculate the relative value of the pound then and now. We haven't done that.
I see. All
But
right.
it doesn't matter because it's a broad picture. And there's another one too, which I'm coming to again for the same purpose, another two actually. Where's the actual Springer? There it is. Oh, one might notice that well, that's in 99, we'll forget about that. All I would say about that is the court thought that disproportionate interference, that penalty, a disproportionate interference with the newspaper's Article 10 right.
I ought to know, Mr. Hampton, but what's the court saying in 101, immediately before it gets to the figures? Is it saying that the journalist would have in England the Reynolds defence?
Sorry, my lord.
Is it saying that the journalist would have in England the Reynolds defence?
Precisely so.
Well, in that case, it's perhaps not surprising that it thought that the imposition of costs was
Well,
disproportionate.
that may be so, and that is the complaint, of course, I make about the order of Mrs. Justice Nicola Davis. I'd won that bit of the case, so there'd have to be a very good reason to order me to pay the costs of it.
I see.
I don't know what the result of this case was. I think they lost in the domestic court. Yes, they did. What this is saying is, if they'd had the Reynolds defence, they would have won, or they should have won. But they didn't, they lost. And they were penalised for losing. But the penalty was nonetheless too high.
Yes. Since the court is saying that there ought to have, in effect, that there wasn't an infringement, that they ought to have had the Reynolds defence, it's perhaps not all that significant to attach too much significance to the exact figures. Or am I wrong?
Well, that may be right, but it is nonetheless, it's not a big point. It doesn't, nonetheless, our imposition of penalties, or the penalties imposed in this case, are way out of line with these. They dwarf them.
Yep.
I mentioned, without reading, a case called Axel Springer, which is in the same volume, but tab 5, 4430. This is coming up a bit more to date, 2012. Axel Springer against Germany. Just make sure I'm not missing anything absolutely essential. But there are in several of these. Yes, can I ask your lordship just to turn that up, just for 2 paragraphs towards the end, at page 4466, paragraphs 109 and 110.
Thank you.
First one is at Little Roman 6. Severity of the sanction imposed on the applicant company.
Where are we? Which page?
Sorry, this is in Axel Springer. It's pages 4466.
Okay.
Volume 11, yes.
Oh, it's a
tab
different
5.
volume, sorry, yes.
My fault. I'm trying to hurry, which is never good.
Always good. Yep. Yep.
Under the subheading, severity of the sanction imposed on the applicant company at Little Roman 6, 109, regarding lastly the severity of the sanctions imposed on the applicant company, the court considers that although these were lenient, they were capable, and nonetheless I insert there, of having a chilling effect on the applicant company. In any event, they were not justified. Now, I tell your lordships what the penalty was, the sanctions. There were 2 injunctions at different times, and in the end, a fine or penalty of 1,000 euros, having been reduced to 5,000 by the German court. Indeed, they were lenient if you compare them with this case. And in the end, the court concluded that there was no reasonable relationship of proportionality between, on the one hand, the restrictions imposed by the national courts on the applicant company's right to freedom of expression, and on the other hand, the legitimate aim pursued, which was protection of the claimant's reputation. He was an actor who played a detective in a television series, and he was caught, I think, trading drugs or taking drugs or something like that. Then finally, a French case in 2015 called Coudert against France. The reference is, again, the same volume, tab 8, page 4558. This...
Sorry, 4,158.
Sorry, 4558.
My mistake, thank you.
This case, it's perhaps one can say, without being accused of xenophobia, not in my case anyway, it's fairly typically French. It's the disclosure of the paternity of an illegitimate child of the Crown Prince of Monaco, Prince Albert II. And can I just turn to the holding? Well, I don't need to do that, do I? I'll go right to the end. Again, the penalty imposed was a relatively small fine, I think 50,000 euros. Perhaps more serious, there was an order that the losing newspaper, magazine, should publish a full account of the judgment. This is something that the French jurisdiction allows for. A full report of the judgment on the front page of the magazine. In the event, I understand, they did publish that, but they also put up a box of their own saying, it's all true. Quite French. May I take your lordship's then to paragraph 151 on page 4600, 4600. The court reiterates that in the context of assessing proportionality, irrespective of whether or not the sanction imposed was a minor one, what matters is the very fact of judgment being given against the person concerned, including where such a ruling is solely civil in nature. Any undue restriction on freedom of expression effectively entails a risk of obstructing, and this is a point that I made earlier, or paralyzing future media coverage of similar questions. If it goes on long enough and the sanctions are heavy enough, people will stop publishing. One might think the issue put before the public in this case was of considerably more public interest than whether or not Prince Albert II was the father of an illegitimate child.
Prince Albert had actually agreed by the time of the publication that he was, I think. And
that's indeed, he had admitted it. Yes. Had admitted it. And that's why I think they felt justified in putting up the box saying it's all true. My Lords, I leave those cases there. They're all in a line. They all come to the same conclusion. You have to be squeaky careful to make sure that the imposition of penalties is proportionate to the issues in the case, and in particular to the public importance, if it be a matter of public importance, of the publication that is being penalised. This is an argument which works in both parts of my case. It works in relation to the order which Mrs. Justice Nicola Davis made about costs. It also works in part 2 in relation to the imposition of the additional liabilities. And if I've done some of the work that my learned friends are going to do later, well, so be it. I'll leave the authorities now, if I may. I have to come back to the 3 cases, Campbell in the House of Lords, MGN against the United Kingdom, thanks very much. Sorry about that. And the decision in this court in Lawrence and Friend Tigers. May I then descend to earth, as it were, a little bit, and ask your lordships to look at the rule under which the judge made the, that is, find that. It's in volume 4. It's CPR 44.2, and it's in volume 4 at tab 29, page 1323. The wording is the same as this, isn't it? Yeah. Now, it's clear that what has happened, rightly speaking, I suppose, is that the court has been given a, find it again, a discretion as to costs. The question is, which your lordships know the answer to only too well, what does that mean? In the context of an order for costs, what is or is not a proper exercise of discretion? I'm not going to stand here and repeat a dictate about what that means to this court. That would be a waste of everybody's time. Can I put it like this? Borrowing actually some words from the Court of Appeal in a case which you haven't even got. I apologize for that. It's called Birchall and Bullard, and it was decided in 2005. And the judge, the Lord Justice who said this phrase was Lord Justice Ward. And he said the purpose of the exercise of discretion under this rule, 44.2.1, was to make a just and fair award of costs. I ask rhetorically, the rule, as your lordships know, says that in general the unsuccessful party must pay, but the court may make a different order, and then there are various things that the court takes into account if it's going to make a different order: conduct of the parties, whether a party has succeeded on a part of its case, even if it's not been wholly successful. Our proposition is that to order us to pay all the costs of the action, including that part of the action on which we had had what was really an important victory in the public interest, was not a just and fair award of costs. It was perverse, it was not a legitimate exercise of discretion, it was unfair, it was unsustainable on the facts of the case, and there was no reason of principle why it should have been made. There are sometimes reasons, of course, why somebody may not get the cost to which he'd otherwise be entitled, perhaps because he's turned down a perfectly sensible offer of settlement, and thereafter, because he turned it down, allowed all those costs to be incurred. Here, the judge gave two reasons, both upheld by the Court of Appeal, why the newspaper had, as it were, disqualified itself from getting the order for costs on that part of the case that it ought properly to have had. The first was that in the event, Mr. Flood had been the overall winner. And the reason for that was that he had got a vindication because eventually he managed to get to a trial of 550 causes of action, hits on the website, that entitled him to an award of £60,000 in damages. There is embedded in that a hopeless, we would say, a hopeless confusion. I was criticized in the Court of Appeal for having proposed that vindication was in some sense divisible. I never had argued it because it isn't. You get vindication in a case of defamation if you win. There are two means by which you can get defamation. One is by, vindication. One is by the award of damages. The public looks, or the audience, or the readers look at the award and say, well, he's obviously wasn't guilty. He's done well. He's got some money off the newspaper. The other is, nowadays, when we don't have juries anymore in defamation cases, the other is they can read the judgment. The judge has said he wasn't guilty. They got it wrong. That's vindication. And that is the only means by which the law of defamation can provide, those are the only means the law of defamation can provide vindication. You have to win in order to be vindicated. That is almost so simple as to be not worth saying. But the judge didn't seem to get it, if I may put it like that, nor did the Court of Appeal. They seem to think that because in the event the claimant, Mr. Flood, had a windfall, I'll say what I mean by that in a moment, and got some damages, that operated as a vindication in respect of everything, including the substantial part of the case that he'd lost. I add this, the number of readers of the part on which he lost is calculated at about, taking a multiplier of 2.5 readers per copy. The number of copies was something like sold on that day, and there was some online publication after that. The number of copies was something over 600,000. that works out at the old figure at about 1.6 million, 1.6 million readers. It isn't the size of the readership which ultimately matters, although that's an important factor. It's the question, what was this order for costs, what was the victory on which this order for costs was being imposed? It was a victory gained in the public interest. Those 1.6 million readers had been told something, according to this court, had been given information which they ought to have. It is said by the judge and by the Court of Appeal, oh, well, never mind all that. He got a victory in the end for the 550 publications for those readers, so he's entitled to all the costs. He's entitled to a vindication for that 1.6 million publication which he lost. It's, we would say, without being offensive, it's a legal nonsense. It's a logical nonsense and it's a factual nonsense. It's not in principle possible to do it, and it wasn't fair to do it. And it wasn't right to do it because of the effect it may have of undermining the value of this court's judgment in the original case. Second, it is said, or the judge said, oh, well, never mind all that, and the Court of Appeal agreed with her on this too. The Times could have settled this case on terms which would have preserved its Reynolds defence before the trial of the preliminary issue of the Reynolds defence, on terms which would not have meant its damaging its defence and which would have avoided all the costs of the Reynolds trial being incurred. Well, this does, I'm afraid, mean that one has to have a severe look and a fairly detailed look at what actually happened at that time in the case. I said windfall, I may go back to this. It was a windfall if the Times had published its qualification to the effect that Mr. Flood had been exonerated when it got it, which was in the early autumn of 2007. That would have been the end of the case. Mr. Flood would not have got any damages, he'd have got no costs, and he'd have gotten no vindication at all. It would have been a 100% total loss for him. It was a windfall brought about not by any fault in the journalism that put the article into the public arena or the research which led to it. It was the fault of the Times legal department in failing to put it up. It was an error. Whether it was born of carelessness or pig-headedness doesn't matter. It was serendipitous so far as Mr. Flood was concerned. He was given the opportunity of obtaining something from the wreckage of total defeat, which he duly went and did. And I make no complaint at all about his £60,000 or about having to pay the base costs of that exercise. The additional liabilities is another question. On the question of settlement, again, we would say, and this does, I'm afraid, involve, I lost time of sight of a clock, that's all right, yes. The deadline is in no danger, I don't think, no. This involves an examination.
We do have, just not so much to you, but to everyone else, we do have quite a clear timetable, and it's important. I know. And you all have to keep to it. And while I'm mentioning that, I should express my gratitude to Council and to all others involved for the fact that we have imposed on you a slightly unusual sitting schedule, and we're grateful to you all for accommodating.
I'm sure we'll survive.
Well, we'll have to.
I'm just looking, I forgot where the clock is, but that's right. I have to keep an eye on it sometimes. But Ms. Wilson says I'm not slipping behind, so that's encouraging.
It is also fair to say that it's about 8 minutes fast, 6 minutes fast.
It is. Is that deliberate?
No, if only I could say it was.
I wonder whether the court has a device that speeds it up as the day.
Thank you for that suggestion. We considered at our next meeting.
I'm sure I shouldn't if it were me. Yes, this thing says it's 4 minutes past 12.
Anyway, let's not worry.
Good, sorry. May I proceed to the question of settlement? According to the judge, the only, excuse me, I had some annoying, I'm sorry about that. Only reason why the Reynolds trial was made necessary was what she called, borrowing from the eloquent language of Mr. Price, the die-hard attitude to settlement that the Times had displayed at the crucial time, which is in the period leading up to the trial. Not so. Put it this way, I hope to satisfy your lordships, obviously by reference to the correspondence I'm right about this. If there was any die-hard attitude on the question of settlement, it's not the Times newspapers. It was the attitude of Mr. Flood and his advisers. In summary, the Times made quite strenuous efforts to settle the case on terms which would not have impacted on their Reynolds defence, except, of course, in this way, and this is important. If they'd settled at all, they would not have had the opportunity of demonstrating the quality of the article. There would have been no judgment from this court, which now forms the foundation of Section 4 of the 2013 Act, for example. The case would have been dead and buried and nobody would have known about it. However, the Times nonetheless made the effort, within the parameters that they had, a good defence, they thought, and they were right. If anyone was diehard, it was Mr. Flood. Times could have said, you sue us. You've sued us. If you want this case to stop, discontinue and pay our costs. Didn't do so. I'll show your lordships that in a minute. Mr. Flood's attitude was, no, I'm not going to settle for anything except total surrender. And that's not an exaggeration by counsel. That's the words of mine, but the fact is not.
Well, he offered to accept less than half.
Sorry, my lord.
He offered to accept less than half of what he actually got.
Yes, but my lord...
It sounded like total surrender.
He was not entitled to anything on the Reynolds defence.
As I understand it, the offer of November 2007 was to settle the whole case.
Yes, it was. And on our side, it was rejected because that involved throwing the Reynolds defence overboard.
Well, it was rejected on the ground that his case was wholly without merit, and that the Times would outspend him by a large margin, so he had better knuckle under.
That was falsified in due course, certainly, I quite agree, by the Times' failure to post the qualification. Instead of offering to post the qualification as a term of settlement, the newspaper should have done it voluntarily and unilaterally. What was being talked about at this stage was settlement of the whole case.
What was being talked about at this stage was before any question had arisen about the website.
Precisely so. And the website publication was added later on. It was not in play. It got into play because the Times made a mistake and didn't put up the material change of circumstances. At this point, it was not in play at all. One starts in this bundle, in this tab 7, I think it is, of, did I give the reference? I can't remember. I did, sorry. Yes, it's the appendix, which is tab 7 of file 1 of bundle 1. In page 168.
168.
168, yes.
168, thank you.
This is the opening shot. This is about 6 weeks after the article's been published. The 18th of July 2006. It's a common form letter of complaint in a defamation action. Nothing's happened at this stage, obviously. And the demands, I won't read them out, the demands for satisfaction are on pages 169 and 170.
169 and 70.
170, yes. The usual things, undertaking not to repeat, retraction and apology, same prominence as the article, suitable damages, and legal costs on an indemnity basis. Following that, there had been an investigation into Mr. Flood's conduct by the DPS, what does that stand for? Yes, the Professional Standards Department. It's part of the police. And he had, as it were, exonerated. If you look at 172, this summarises what the Times had been told.
The article on the website, was that identical to the article in the hard copy version, or was it different?
I think it was identical. And it should have been qualified by the information that he'd received as clearance, exoneration, exculpation. It should have been posted at about this time when they received it. It wasn't. And that's why they wound up paying £60,000 in damages and all the costs of that exercise. There were very few publications, certainly, but it was a serious matter, and they should have done it. I don't complain about that at all. What I do complain about is the idea that there was a way in which the Times at this stage, in early autumn 2007, could have been expected to settle the whole case in the way that Mr. Flood wanted, without sacrificing their Reynolds defence, which was 2 years away from trial, or nearly so. It was tried in July 2009. Could I ask your lordships to look at a letter of the 14th of September?
So, can I just
Sorry.
press you on that? Suppose that the website publication had been pleaded as a distinct publication at the outset. Would the point that you've just made have been just as good?
But they were pleaded as part of the original claim, those website publications that had taken place by the time the claim was issued. Yeah. In other words, there was a series. Put it like this, within the privilege accorded, the public interest defence accorded to the newspaper by this court, there was the original print publication of 600 and something thousand copies, and there was also a series of website publications. The cut-off point comes, in theory, as you'll see that Mr. Brett, the Times legal advisor, said, cut-off point comes when the Times gets notification from the police that the investigation has ended in Mr. Flood's favour. That's the point at which not the defence ceases to exist, it ceases to exist only if they don't put that on top of the article on the website, and that's what they didn't do. That gave Mr. Flood a lifeline which, if they had done it, he would not have had, because if they had done it, that would have been the end of the case.
Well, yes, but you're going to take us through this correspondence,
Yes, I am, yes.
But I mean, the debate in the correspondence is about the terms in which the qualification, semi-retraction, or whatever it may be, correction ought to appear.
Yeah, that was because there were two versions of the qualification. They both, I mean, I accept this, they both had, and either would have done the trick, they both had the effect of exonerating Mr. Flood. He had one version, and we had another that the police had sent us.
You say they were the same?
It just makes no difference. I would have said the one we had was effective to exonerate him, but that wasn't the problem. The problem was, as your lordship sees, the problem was that Mr. Flood wanted the earth. He wanted everything.
I see.
He wanted an admission, for example, that the article should never have been published. He wanted an admission that it had said things which it didn't say. And he wanted a whole lot of money on top of that. For an article, for a case which in due course was totally vindicated by the judge and by this court.
Right.
At least the Times had the wit to stand its ground on that issue. Thank goodness. May I go to page 171, which comes just after the Times has received the piece of paper from the police saying, reading from 172, the Metropolitan Police's Directorate for Professional Standards, thank you for that's what it is, has now concluded its investigation into Detective Sergeant Flood and found there is insufficient evidence to proceed with any criminal prosecution, and Detective Sergeant Flood will not be subject of any disciplinary proceedings.
What were is that a quotation of the terms of the notice?
Yes, I
better verify. At some point, at any rate, it said no evidence, didn't it? That
was the other piece of paper which we didn't have. Here it is. Can I read it out? This is in paragraph. This is the version we had. The exact wording, which you can compare with what's on the page in front of you on page 172. Yes. It's paragraph 242 of Mr. Justice Tugendhat's judgment, which is in the same volume, yes, page 326.
Thank you.
What actually was sent to the Times by Detective Chief Inspector Crump was this. Having considered all the available information, I am of the opinion now that there is insufficient evidence to proceed with any criminal prosecution. I am also of the view that insufficient evidence exists to mount any internal police disciplinary process.
And then you see unable to find any evidence at the top, yep.
Yes, that's right.
Yep, thank you.
But, my Lord, that's not what this turns on. If there had simply been a dispute about which form of words should be used for the exoneration, I dare say the settlement would have been arrived at very readily, because that, if you look at page 172, is what Mr. Brett, on behalf of the Times, was offering. And I'll come to his offer to change the wording in a moment. He says, in addition to this follow-up piece reporting the outcome of the investigation into the client, we would, on a totally ex gratia basis, be prepared to pay our clients reasonable legal costs to date on a standard basis and without any CFA uplift. Two things about that. First, it could have worked as a term of settlement, the offer to publish the exoneration. It isn't a sufficient excuse that it didn't, not to post the qualification in any event. That's what the Court of Appeal found, and we didn't appeal from that. It's plainly right. So did Mr. Justice Dugan. It didn't take more than a minute to do it, but that was the fact of it. Second, the offer to pay Mr. Flood's costs at this stage, when the Times had a viable, and I say now valid, Reynolds defence, the offer to pay Mr. Flood's standard costs without uplift was actually very generous, and he should have taken it. At this stage. One sees what the response is on page 175, 10 days later. At the bottom of the page, whilst we note your offer to report the outcome of the MPS investigation, your proposed wording adds insult to injury. And then over the page, third paragraph, our client would be happy to settle these proceedings.
Well, in fairness, they explain why.
Yes, they do.
Yes.
Yeah. Yeah, but it's again, one looks back at the judgment of this court, it was in a sense why, it wasn't, but in fact, what happened was, there was an investigation, it was allowed to fall into inertia. The newspaper took it up, and then it was continued. The police then got a search warrant for Mr. Flood's house and so on and so forth.
Yes, I know.
Yeah, well, I know you do.
This letter is the 24th of September of 2007. Have the Times by then had the exact terms of the investigation report?
It looks as if they did, because they describe, the way they describe their proposed statement is following on almost word from word.
Yeah.
Press release.
Yeah.
Now, what did the press release say?
Well, I don't know.
I see.
Well, the critical thing is what's in...
But I beg your lordship's pardon. I don't believe it matters in the slightest what it said, because it wouldn't have satisfied Mr. Flood.
I see.
Thank you.
He would have been satisfied with neither of those forms of words, and the reason for that becomes crystal clear in a moment. On the other side of the page, on the other side of the file, 16176, third paragraph, our client would be happy to settle these proceedings, but to do so, he requires proper and full vindication, and thus needs a proper apology, published with reasonable prominence, payment of all his costs, and payment of suitable damages. Excuse me. In regard to the apology, we enclose a draft for your approval. The prominence of the publication will also have to be agreed. Over the page, one sees what it was, and one immediately sees why, in the circumstances prevailing at the time, when the Times believed, rightly as it turned out, that it had a cast-iron Reynolds defence, this is what they were expected to say if they were to settle the case. At page 177, draft apology. Detective Sergeant Gary Flood, an apology. On the 2nd of June 2006, we published an article entitled Detective Accused of Taking Bribes from Russian Exiles. It stated that Detective Sergeant Gary Flood of the Metropolitan Police Service Extradition Unit had been accused of selling confidential information obtained during the course of his duties to Russian exiles. Well, if one remembers what it was, the way in which Lord Phillips described the matter in his judgment, that's absolutely right. Now, the Times is supposed to go on and say this. We are now happy to confirm not only that Detective Sergeant Flood did not act in such a way, How can they possibly do that? They had what the Supreme Court called a good circumstantial case that indeed he had acted in such a way. And also, we are happy to confirm, not only that, but also that he, Mr. Flood, was never in fact accused of doing so. Indeed, he was accused of doing so, as stated in the article. We also wish to report that he's been exonerated following an investigation, well, that's correct. The Times accepts that it made an honest mistake in publishing these accusations, and it apologises for distress caused, and has agreed to pay him legal costs and suitable compensation. Given the way in which this court characterised the information available to the Times at the time of publication, and the way in which it characterised the effect of the publication, this apology is utterly unacceptable.
But why is it wrong to describe that as an honest mistake? There are many circumstances in which you report something in the public interest, and for which you, for that reason, would not be liable. It then becomes apparent that although you acted in perfectly good faith, there was no evidence which could justify that. So why is that not correctly described as a situation in which the Times made an honest mistake?
It didn't make an honest mistake. It made a deliberate decision to publish public interest information.
Yes, but it couldn't justify it.
It didn't have to. It's got a public interest offence.
Yes,
it didn't make a
this is
mistake
not a
in publishing.
statement about the decision of the Times to publish something in the public interest. This is a statement to the effect that they clearly honestly believed that those allegations were right, but it's turned out that they weren't.
They didn't say that they were right. They never did. They said these accusations have been made and the public ought to know about them. That's the nature of the case, which is being undermined by these very words. We had a justification in what I call the moral, not the strict defamation sense. We had a good cause to publish that article. It informed the public of what the public needed to know, not what it might have liked to hear, what it needed to know, and we didn't get a single thing wrong. The journalist's conduct was vindicated by the Supreme Court.
It may be an oversimplistic view of this case, but on one view it throws up a problem which judges, when deciding how to award costs, are frequently faced with. What you're saying is that the claimant asked for too much, you would say much too much, and he got much less, but he got something. And whether it's damages or some other sort of relief, the difficulty for judges in such a case is that do you give the claimant all his costs because he's got something from the case that he wouldn't otherwise have got? Or do you dock something from his costs, or possibly do something even more, because he was asking for too much?
Of course.
And that, it might be said, when one stands back, is a classic difficult decision for a judge, with which an appellate court should be very reluctant to interfere. Now, you may say this is oversimplifying this case, and of course it oversimplifies any such case, but as a matter of general concept, what would you say to that?
It's peculiar. What I'm going to say is slightly roundabout, but defamation is peculiar. Defamation depends on proving that you have been, something has been said about you, which is untrue, or false, to which there is no defence. Then you get damages, you get vindication, and so on and so forth. Each publication of the defamation is a separate cause of action. The vast majority of the publications complained of in this country had a defence. They did not attract, could not attract any penalty at all. It would be fair to say he won something. Yes, it would. Does that mean he should have the whole cost of the action, when in fact he lost the most important part by a mile?
Can you add into the ingredient here that at the time of these exchanges which we're looking at, the only issue in the arena was one on which you, leaving aside justification, which wasn't necessary if you won on the Reynolds point, the only issue that mattered, and it's one on which you won, was the Reynolds issue.
Precisely so. It was
a year and a half later, or nearly 2 years later, that they suddenly realised they've got another point.
But, my Lord, that is precisely the position. At this juncture, and one cannot look at it in that sense with hindsight, at this juncture what mattered was, what was it that the Times was being expected to give up and admit to? It was expected to give up its Reynolds defence and admit that it had no defence, that it made some obscure kind of mistake. It didn't make a mistake.
No, your point on that is the information may have proved mistaken, but they didn't actually make a mistake. You can't say that somebody who publishes in Reynolds privileged circumstances is making a mistake. They're entitled to do what they are.
On the contrary, they've made a deliberate decision which is in the public interest. Yeah. And it's not a question of discretion, it's a question of principle. And the decision by the judge was unprincipled. It awarded Mr. Flood something in costs. It ordered him a huge penalty to him against us in costs, to which plainly he was never entitled. Never. He lost hands down. And at this stage, what the Times was saying, repeatedly, we'll have to finish this, repeatedly, we have a Reynolds defence. We're not going to apologise. We've nothing to apologise for. Just go back to the question of which form of words. The next letter, which is 178, 28th of September, page 178, again, Mr. Brett says, I'm sorry, the first paragraph, my letter of the 14th September has elicited nothing more than an outright rejection of what was meant to be a positive move trying to resolve the differences between your client and Times newspapers. Bottom, just before the repetition of the form of words, just so you are no doubt what I was proposing as a follow-up report, as is set out below and as said previously, I'm perfectly happy to consider any changes that you would like to make to make it more acceptable to your client. He's not wedded to the form of words which he took from Detective Chief Inspector Crump. He said, give me some changes and I'll think about it. And then there's some stuff in between. The bottom of page 179, I therefore come back to my original offer of a follow-up report and payment of your client's reasonable legal costs to date for an ex-gratia payment and in an attempt to resolve the matter before further costs are incurred. If you really do want a follow-up report to appear in the paper, you only have to say so. And then one can go on to the response on page 181. Thank you for providing the copy of the letter from Mr. Crump dated the 4th of September. And then the 1, 2, 3 paragraphs below that, this is absolutely crucial. You state that you are happy to consider any changes to the proposed follow-up report. We have made our suggested changes as set out in our letter dated 24th September. We assume they have been rejected. That is the grovelling, unconditional surrender apology which your lordships have seen. Those are the changes which apparently he wanted to what I might call the Crump exoneration. I repeat, here is the Times, as it says in a minute, sitting on what they think is a good defence, and what this court has said in due course, the judge and this court said, yes, you were right, it was. On the next page, 182, second paragraph, third paragraph, as regards, this is from Mr. Brett, as regards the report on the outcome of the investigation into your client, which might appear in the Times, what I suggest in my last two letters is light years away from what you wanted in your letter of the 24th of September, which is headed apology, and goes on to assert that there was no basis or truth in the article which appeared in the Times. Indeed, what you wanted published, and is attached to the letter of the 24th of September, and he's absolutely right about that, is nothing more than an admission of liability, and states at the end that we have paid your client's legal costs and suitable compensation. With the greatest respect, that is manifestly unacceptable when, as you know, we have mounted a clear Reynolds qualified privilege defence and made it clear that insofar as the article meant that your client was the subject of an internal police investigation and there were grounds which supported that police investigation, the article was true in substance. In fact, that is what I call the low-level plea of justification. What matters is the first part of that sentence. He knows or believes that he's got a cast-iron Reynolds defence. Why should he grovel? Why should the newspaper say they made a mistake in publishing the article? No basis whatsoever for that. And then over the page, can I, second little paragraph, 2 lines, can I ask once again, do you want us to carry a report, the outcome of the investigation, along the lines of what I've sent to you or not? 12th of November. This is his offer now, Mr. Flood's offer. It's page 188. We write further to our recent correspondence in connection with the above matter. In a final attempt, this is why I said that it was Mr. Flood's attitude that was die-hard, not the Times's. In a final attempt to try to resolve the above matter before costs escalate, our client is prepared to settle the proceedings upon the following terms. You publish in the next available edition of your newspaper in a sufficiently prominent position to be agreed the attached article. Over the page one finds it. It is identical to the one which was sent on the 24th of September. Go down on your hands and knees, grovel, apologise for having made this frightful mistake. That's what it says. We got everything wrong. We should never have published it. And then an undertaking not to repeat, payment of damages in the sum of 25,000, and all our clients' costs incurred to date to the acceptance, inclusive of the success fees of both ourselves and counsel. Who's being die-hard, one asks rhetorically? Is it the Times or is it Mr. Flood? At this stage in the proceedings, as things turned out, it is Mr. Flood who's asking for the moon, and it's not in the Times's, not reasonably in the Times's power to give it to him. He wants everything. Why should he have it? Is it unreasonable of the Times to reject this? As it did on page 190, third paragraph. Well, third big paragraph, last paragraph on the page. The advice I have received is that, and he uses my name, I don't think that's any lustre to what he's been told, but still. The advice I have received is that we have an extremely strong Reynolds defence in this case, as it was of public interest and importance, and the journalism was entirely responsible and reasonable. Well, that's prophetic. It's almost as though he's clairvoyant. But he's right. Like the unsuccessful so-and-so case, there is no chance of our settling this litigation by payment of damages at any cost, and we will and are prepared to take the action to trial. One has to say that is entirely reasonable in the circumstances prevailing at the time. That is what we would say he ought to have taken. That's the position he ought to state on behalf of his newspaper. And then there's a further offer of follow-up and a slightly reduced form of financial settlement offered on the next page, 191. And one can turn over.
But you accept, I take it, that we have to read the whole paragraph and the whole letter to get the flavour of the...
Oh, I think so, yes. There are two things, my Lord, that do go hand in hand. I'm trying to save time. I'm asking the question, which I believe is a rhetorical question. Was it right to characterise the Times' behaviour as die-hard or unreasonable in the course of this negotiation, if it was a negotiation for settlement? My answer to that is plainly no. They had a good Reynolds defence, which the only terms which were being offered or counter-offered would have involved the sacrifice of that defence, as well as the payment of quite a lot of money, including the success fees of both counsel and the witnesses on an indemnity basis. Well, I can leave the correspondence there. There is more of it if the court should wish to read it, but perhaps that's enough, because that really is the end of it. After that, the question is, until the trial of the, Reynolds defence took place in July 2009, can it reasonably be said, which the Times won, can it reasonably be said that the Times' refusal to settle on these sorts of terms was unreasonable? Or is the fact that Mr. Flood did not get a settlement before that date, when, as I say, the issue was decided in the Times' favour, was the reason why Mr. Flood did not get the sort of settlement he wanted, was that his terms were totally unreasonable, given the circumstances? The answer to that question must be yes. This is not a question of discretion. This is a question of pure fact and principle. If it be right that the answer to that question is it was Mr. Flood's own fault, the Times' attitude was proper and it was reasonable, then there is absolutely no reason under the rules, 44.2, why Mr. Flood should have been awarded all the costs of the action. It should have been divided. If there was a winner overall, it was the Times, because it was a much more important issue, but no matter. You don't have to have a winner and a loser. The Court of Appeal said that many times. If you look at the thing overall, you've got a substantial victory for the Times and you've got some sort of victory for Mr. Flood. He happens to be the claimant, so he gets an award of damages. I wonder what the award of damages would have been if defendants could get an award for having, as it were, been falsely accused of publishing an article when they shouldn't have done. But they don't get damages. What they get is the satisfaction of knowing that their article was upheld in the Supreme Court eventually. What now? No, I mean, I will do that. When I was talking about vindication, Ms. Wilson said I didn't talk about the essence of vindication. I did mention, I know, but what I didn't do when I was doing that was to go to give your lordships the references to vindication in the Court of Appeal's judgment. I'm not going to, unless your lordships wish me to do so, partly for lack of time, but partly because I don't think it's necessary. I'm not going to go to those paragraphs. The relevant paragraphs in the Court of Appeal are, in the Court of Appeal's judgment, the file is the same file. The tab is 4.
Yes, yes.
The paragraphs are 4 to 5 at page 144.
Yep.
27 at 149. And what I regard as the villain of the piece so far as the question of vindication is concerned, 36 to 39, including the observation at 38 on page 152 that I had said that vindication was divisible. It's no such thing. You either get it because you win or you don't because you lost.
Thank you. Well, we have the paragraph. Thank you.
On the whole, my own belief is that it doesn't advance the shining hour to spend hours poring over earlier judgments. If your lordship can read them, if my submissions are right, well then you'll reach your own conclusions. Where was I? I think I've done with this question of settlement. I would only make this observation, again, not for reading now, but we have given at paragraph 37 of our case, which is on pages 90 to 91 of tab 7 of this same bundle, a fairly, it's not, I won't say it's neutral, it's not, it's a tendentious commentary on this question of settlement.
Sorry, where's that?
It's in our case, which is in tab 7, I think.
I'm sorry, yes, I was looking at
That's my fault. Sorry. You're quite right. 5, yes, 5. Page 90. Page 90. You're tempting me to read it, but I know that that's going to benefit. Page what? Tab 5. Page 5. Tab 5.
Yeah.
Oh, I see. I'm so sorry. I was in the appendix. And paragraph 37 starts at the top of page 90.
Yeah.
And it goes through onto, I think, as far as 91. That is an attempt to render in writing what I've been saying orally this morning. Your lordships will make of it what you will, of course. It may bear reading down the line when your lordships are considering this matter. That was on vindication, was it? Was that on settlement? That was on vindication. What? Well, that's the wrong part, is it? Never mind. No, that's on settlement. That's quite right. There is one particular line of authority which is, I suppose it's mostly English, because the burden of costs in this jurisdiction appears to be very much heavier than it is anywhere else in Europe. The financial penalties for losing in this country, particularly perhaps in these publication cases, is enormous in ordinary people's terms. £1.6 million. And so the pressure of financial considerations is one of those things which both the parties have to take into account. Now, there are some quite valuable statements about this in the English authorities. They're best looked at because they're all together in the same place. In the judgment in MGN against the United Kingdom, which afraid this means another file or bundle or whatever it's called. It's in volume 12. And this I do ask your lordships to look at.
Another one is one we've looked at, yeah.
Fair enough.
At tab 3.
Right. The says it's not the last time we're going to look at this case over the next 3
No,
days.
I'm afraid that's right. And that's one reason I'm not going to go through it with a fine-tooth comb. I'm afraid I will have to ask your lordship to look at Lawrence for obvious reasons.
Yeah.
Or remind yourself, I should say. Now, again, I can do that very quickly too, but this is just some very short references to English cases and the views of the English Parliament also on this question of the relationship between financial penalty and the pressure to settle.
Yeah.
The first one is a paragraph 98 on page 4835.
Thank you.
4835.
4835.
Yes.
This is a decision of Mr. Justice Eady. There couldn't really be a better source of wisdom if you're a defamation practitioner, in a case called Turku and News Group Newspapers in 2005. And he talks in paragraph 6 of his judgment about the problem of cost. The last sentence of paragraph 6, on the other hand, if the defendant is unsuccessful, it may be ordered to pay, quite apart from any damages, the cost of the defendant's solicitors, including a markup in respect of success fee. That's in part 2. I say it now, I don't come back to it in part 2. Other people may want to do so. The defendant's position is thus wholly unenviable, and for present purposes, it's the next paragraph that matters. Faced with these circumstances, there must be a significant temptation for media defendants to pay up something to be rid of the litigation for purely commercial reasons, and without regard to the true merits of any pleaded defence. No wonder then that Mr. Flood's terms were not met by Times Newspapers Limited. They had a cast iron defence, and they had the courage of their convictions. They did
It
not
cuts both ways, doesn't it?
Huh?
I mean, there's an enormous risk for the claimant as well.
Surely.
And indeed, in the correspondence apropos settlement in 2007 and in 2010, the Times basically said, we'll ruin you, we'll spend enough money to ensure that this will deprive you of your home and everything you've got.
And that may well be, and I quite accept that, and that may well be one of the reasons why in the award of damages was included £15,000 worth of aggravated damages. That is not an answer to my proposition. Was it unreasonable for the Times to adhere to its Reynolds defence at that stage in the proceedings? That is what the judge said, and the Court of Appeal, and it wasn't. Indeed, one might say they were obliged to do so. Sorry, my Lord.
No, please. I was only going to say, somewhere there's a fuller explanation of the facts of Turku.
It's in the files.
It's a classic blackmailing action, isn't it?
Yeah, sorry.
It's a classic blackmailing action.
Yes.
And King has some features in common with it.
Well, that's one of the weapons, and particularly the success fee,
Quite.
in unscrupulous hands,
Yes, I
which
follow all
causes
that.
so much trouble.
Yes.
It is antipathetic to the exercise of freedom of speech.
Right.
It's a vicious weapon. I mean, it's a huge club.
Yes, got that.
Yeah, good. All right. And then another case, this time in the Court of Appeal at letter C on the same page, 4835, paragraph 99. This is Lord Justice Brooke.
Yes.
To the same effect, but not quite. Where what is an issue in this case is the appropriateness of arrangements whereby a defendant publisher will be required to pay up twice the reasonable and proportionate cost of the claimant if he loses or concedes liability. and will almost certainly have to bear his own costs if he wins. The obvious unfairness of such a system is bound to have the chilling effect on a newspaper exercising its right to freedom of expression and lead to the danger of self-imposed restraints on publication, which he so much feared. I don't know who the he is in that sense. It's that, my lord, that authority is also in the bundles, in full. It's very well put, although I don't know whether any of them were lawyers, but it is very well put at paragraph 116, I think, by the Parliamentary Committee on Media, Sport and something or other. 116 on page 4842. Culture, Media and Sport Committee. This has published this report in, it's headed Press Standards, Privacy and Libel, and it was published on February 24th, 2010. In its introduction, the report noted, and I'm only going to read the first paragraph of this, throughout our inquiry, we've been mindful of the overarching concerns about the costs of mounting and defending libel actions and the chilling effect this may have on press freedom. The evidence we have heard leaves us in no doubt that there are problems which urgently need to be addressed in order to enable defamation litigation costs to be controlled more effectively. We find the suggestion that the problem confronting defendants, including media defendants, who wish to control their costs, can be solved by settling cases more promptly, to be an extraordinary one, proposition that is. If a defendant is in the right, he should not be forced into a settlement which entails him sacrificing justice on the grounds of cost. Hear, hear. And that's quite without any reference to the additional liabilities. Why should a media defendant who serves the public interest with his article cough up and bow the knee just to avoid additional expense? He may have to. He may be a small local newspaper. The Times, fortunately, in this case, isn't. So it was able to carry on and win the day at trial and again in this court. Principle vindicated, one would say. The effect of what the judge was suggesting was that principle should have been sacrificed on the altar of commercial expedience. Not acceptable. Lords, can I then move from that question? I summarise, I hope correctly, what I've been saying is in this way. The judge's order, so far as the Reynolds defence is concerned and the costs of it, was not a legitimate exercise of discretion at all. It was an order which no reasonable judge, having regard to the principles of law involved in relation to vindication, having regard to the importance of the case that had been won in the public interest, she knew that by that time, of course, and having regard to the burden which her order was going to impose unfairly on the victor in that part of the proceedings, it was an order which ought never to have been made. It was unprincipled, it was illogical, and it was unsustainable on the facts of the case.
What do you say about the judge's observation at paragraph 21 to the effect that as far as the evidence was concerned, the defence, the Reynolds defence and the justification defence largely overlapped?
Lorgie, no, it's absolutely, I mean, we would have to get them.
Page 167.
Yes.
Well, no, yes.
167, I'm probably going to find my...
Tab 6 of the core bundle right at the end.
Yes, I've got it. I've got it here. 167. This is, I think, in the context, was it not, of what I might call the difficulty of allocation.
Yes.
Which paragraph?
Well, I don't think it's just a question of the difficulty of allocation. It's paragraph 21.
Yes.
I think the point that the judge is making is that when you look at the proceedings as a whole, the costs had been occasioned to a large extent as much by a defence of justification, which was eventually abandoned, as it did with the maintenance of the Reynolds privilege, because the quality of evidence was very substantially similar in both cases.
There were similarities. To say that there was a substantial overlap, I doubt. And I'm nervous because I haven't got the pleadings with me. And I'd like to be able to show them to your lordship so that you could test whether it's true.
Not just a question of the pleadings, is it? I mean,
Well, it's a question of what? No. Well, there was no evidence. There was no evidence advanced at this stage or at any stage. It didn't involve any expenditure in court at all. The plea of justification, none. It was a paper exercise. There was an extent to which there was an overlap. It's perfectly true, and the extent of that overlap would no doubt detract from the amount which Times Newspapers Limited, or it would even out, I would say rather, with the amount that the Times Newspapers was entitled to for winning the Reynolds case. No doubt on assessment, I think we've said in our argument that we would not expect to get the cost of the justification issue. On the contrary, that would go with the order for costs which the judge made. It's only the Reynolds issue which I wish to be, as it were, excised from the order and, as a matter of course, reversed in favour of the defendant newspaper. For reasons not just of fairness in this particular case, but for reasons of public policy.
I mean, if one excludes the later website publications, the fact that the evidence would overlap between the Reynolds defence and the justification defence would be irrelevant. If you succeeded on the Reynolds defence, then you presumably get the whole of the costs.
Well, of course, everything from
even
that
if you lost
time,
on the justification, or it became irrelevant.
we withdrew it, in fact. And the reason we withdrew it was that the judge, Mr. Justice Tugendhat, determined the meaning of the words late on, I think sometime in early 2013, in a form that we couldn't justify. So we thought, well, what's the point of defending something which was not an allegation we thought we'd made, but the judge said we had, and we couldn't defend it. So we drew the justification, but he get all the costs of that anyway. Of course he will.
But your point, as I understand it, is that if Reynolds succeeds, you don't need justification anyway.
Well, that's always been our position.
Yeah.
But by that time, thanks to the mistake in not putting up the Luchansky qualification, I'm sorry to use a colloquialist,
You did need
that option had been thrown overboard
You
by
needed
the
it for
newspaper.
the website, yes.
Yeah.
So Mr. Flood got his chance, which he shouldn't have had.
Do we have to understand the subtleties of the way in which Mr. Justice Eady ruled on meaning? I mean, your case is that, presumably, that you had an arguable case on meaning and you proved to be wrong.
I can summarise it. It's very simple. We could get the piece of paper to court if necessary, but we had pleaded that it meant that there were grounds for an investigation into Mr. Flood's conduct,
Yes.
and no more than that. When Mr. Justice Tugendhat came to deal with the matter in the beginning of 2013, he said, no, it goes further than that. It means that there were strong grounds to suspect that he was guilty of corruption. I'm paraphrasing, but that was the effect of it. Our evidence did not, and our particulars of justification, did not match that meaning. It therefore became for us an impossible task to win justification. And we certainly were not going to go to the Court of Appeal on that ruling by Mr. Justice Tugendhat because it was one which was well within his compass. So we went to trial naked, if you like, because we were unable to settle the case on terms at that stage. Now, if one said post, as it were, the decision in this court, oh, well, you should have settled the rump of the trial, the rump of the case, that's to say the question of what damages he should get and so on and so forth, why then it could well be said we should have done. If we had done, we would not have paid the price of £60,000 in damages and all the costs of that part of the trial. But that has nothing whatever, it cannot be retroactive. It has nothing whatever to do with the question whether the Times should have cast aside their Reynolds defence in order to settle the case at a time before it had been determined in their favour. Lords, I am now prepared, and I'm conscious with some relief, that I have only got another 50 minutes odd, perhaps another... May I take 5 minutes and just saying something about... Sorry, what's the matter? Have I left something behind? saying something about the next part of the case. This is most of it uncontroversial, I hope, until I get to what I think is the effect of MGN and the United Kingdom. This is all somewhere or other in the Van Tigers case, the latest decision of Your Lordship's Court. CPR 4321A, which is at tab 18 of volume 4, at pages 1171 to 72. I got that. It's not in this, is it? I seem to have it. Thanks very much. That says, and this was carried over. It doesn't matter, but this is the order that was in force at the time when the judge in our case made her order. 4321 on page 1171. A, costs includes any additional liability incurred under a funding arrangement, and those things, funding arrangement and additional liability, are defined. This is, I'm afraid, old hat for some of your lordships, at K and O on the succeeding pages. The problem with that is that it is indiscriminate in its application. It is universal, and therefore, for somebody with a convention right to assert in relation to costs, is inescapable. I've tried to see how it might be that the practice direction, which was then in force, might be read down, or I would say have to be rewritten. I, like Lord Hoffman, and in a Campbell case, and like my Lord, the President here, there's an illuminating passage in Fen Tigers, Lawrence, which I'll come back to after the adjournment. The proportionality which is spoken of in the practice direction is nothing to do with what I might call convention rights, convention proportionality. It's no, you can try and read it down as hard as you like, you get absolutely nowhere because you're not reading down the right thing. So the world, for the present, is stuck with this CPR rule. And it is, the effect of that is actually confirmed by one of the practice directions, not the section 11, but section 9.1, which says that costs will include the additional liabilities. That means there is no escape. The statutes which, under which those rules were promulgated, statutory instrument, were permissive. So there's no point in my saying the statutes are incompatible. They're not. They simply allow for this to happen. Whatever happened between that, I know not, but evidently nobody gave any thought at all to the impact that this provision might have on convention rights, whether Article 10 or any others. There is no scope in that rule and the practice directions under it which allows for proportionality to be introduced into the assessment of costs, not proportionality of the kind we're talking about in this case. Proportionality, yes, in the sense of is it proportionate to the issues in the case, etc., etc. That's what it's what's I think called Lowndes proportionality, but that's not convention proportionality. And this means that one is, as a defendant, one is caught. The imposition of the additional liabilities is automatic and inescapable under the existing regime. This means that there's a stark choice. And this, we believe, is what effectively the European Court of Human Rights decided in the MGN v UK case. One is left with a stark choice between that case, which in effect, and I hope I may be forgiven another colloquialism, the European Court in that case binned the whole thing. It didn't allow for any exceptions. It couldn't do. And the reason was that the whole scheme is indiscriminate. It makes no allowance for public interest journalism or other kinds of proper exceptions to the impact of the rule. The choice then is between that and a decision by the House of Lords in Campbell and Mirror Group newspapers in 2005, in which it was held, despite the obvious disadvantages of the scheme so far as public interest publication is concerned, the scheme was nonetheless to be upheld because it served the legitimate interest of providing access to justice. This is a choice which perhaps I can address after the adjournment.
Certainly. Is that a convenient moment? That's a convenient moment then.
Yeah.
Thank you very much. We'll resume again at 2 o'clock. Court's now adjourned.